How can I get my court order changed? Hi, I'm Bill Farias, founder of Farias Family Law, and this is a question commonly asked by people who are not happy with their current court order. They want to know whether they can get it changed and how they can go about it. So in Massachusetts, the way that you get a court order changed is called a complaint for modification. And the standard for a complaint for modification is called a material change in circumstances. So to get in the door, to get into the court system, to ask the court for a modification, you have to show that there has been a material change in circumstances. So this falls into two categories. One is child support. When there's a child support issue, you are eligible for a modification if the child support guidelines calculation that you run today recommends a number that is different than what was recommended the last time you were in court and got a court order put into effect. So if the numbers today are different than it was when the current order was put into effect, then you're eligible for a modification. The only other thing you have to think about is if there was a deviation in the past. In other words, if the parties or the court, if the parties agreed or the court ordered that there should be a deviation from the amount recommended, then that has to be also, and the grounds for that deviation are still present today, then that has to be taken into consideration in determining whether the order should be modified. The other category is everything else besides child support. So typically it's alimony, health insurance, custody, parenting time. And for those issues, again, the standard is material change in circumstances. Since the last time you were in court and got the order put into effect, has there been a material change in circumstances? So judges do have a decent amount of discretion in determining what constitutes a material change in circumstances. In the case of alimony, for example, it would have to be something that would significantly impact either the payor's ability to pay, for example, a decent drop in income, or something that would affect the recipient's needs. For child-related issues, for example, custody, parenting time, it would have to be something that would have a significant impact on the parenting time or the well-being of the children. The bottom line is that before filing a modification, you should talk to an experienced family law attorney to determine whether the grounds for filing are sufficient. So let's also talk about some potential pitfalls and what is not sufficient for a modification. So first, buyer's remorse. So this is very common. Somebody signs a stipulation and then a few days, weeks, months later, they regret it. I shouldn't have done that. It's not working. And unfortunately, that is not sufficient for a modification. Again, you would have to show that there's been a significant change. Just simply regretting the agreement that you signed off on is not enough. The other thing to keep in mind is that when filing a complaint for modification and putting a certain issue in play, you have to be aware of the fact that the other side may counterclaim on a different issue. So this is not to discourage people from filing modifications, because sometimes it's necessary and in your best interest, and if you have children, in the children's best interest to file. However, before filing, you have to make sure that you weigh the potential benefits of addressing the issue that you're identifying and getting the outcome you want with the potential costs or risk of having a counterclaim filed and dealing with that. So a perfect example is sometimes a parent who is receiving child support wants an upward adjustment of child support, and so they file a modification to address that. However, they may not want to re-examine the parenting time. So they want more child support, but they don't want to run the risk of the other party getting more parenting time. Well, if you file a complaint for modification on child support, then the other parent has the option of counterclaiming on custody or parenting time, so that those issues are then in play also. So again, the bottom line is make sure that you assess this thoroughly up front with an attorney you trust before filing any complaint for modification. So that's how you can address any changes you may want in the current court order. If you have any other questions on this, feel free to call us at 508-675-0464. You can email us at info@fariasfamilylaw.com. If you found this video helpful, you can subscribe to our channel and share this with anyone who might benefit from it. And you can also find us on Facebook at Farias Family Law. Thank you. Have a good day.